Welcome to this webinar of Dua Associates. I am Mr. Hetal Thakur, partner of Dua Associates, a full services law firm having a pan-India presence which handles litigations of various types and various types of matters. Our firm handles litigations in all courts and tribunals and arbitration matters all over India and even outside India. Today we propose to take an overview of the feasibility of virtual courts or e-courts. Can they be the new normal, which is today a point of concern in the light of the present situation which we are all faced in. We have on our panel Mr. Rahul Chitnis, counsel practicing in the Supreme Court, who has agreed to address us on this issue. Mr. Rahul Chitnis was earlier practicing in Bombay High Court, and after a flourishing practice in Bombay, is now practicing in the Supreme Court, where also he is making his presence felt. He has argued various types of matters in this era of what we call virtual courts, and he can bring on the table his own experiences as to how he has experienced the e-courts as they are now functioning. Mr. Chitnis, can you please take over to address our participants?
Good evening, friends. Let me just start by sharing my screen because I have a PowerPoint presentation which I need to share with you. So I have to. Is it sharing this thing presentation or no?
No, the screen is not sharing any.
Okay. 1 second. Give me 1 minute. Yeah. One second. Let me just get this sorted out. Give me a minute. Yeah. Yeah. Is it now sharing?
Yeah, it is now sharing.
Can you see the screen?
Yeah. I can see the screen.
Yeah.
Yes.
The topic for today is e-courts. Can they be the new normal? The first thing, there are several stakeholders in the justice delivery system, and they are mainly the judges, the advocates, litigants, and the public. Today, the public are also a part of the justice delivery system because there are several public interest litigations which are filed in the country, and the public also has needs to know what is happening in the courts with regard to that particular issue which is going in the courts. Like yesterday, the Supreme Court was dealing with the issue of the migrant laborers. On Thursday, it was dealing with the issue of migrant laborers in the country and what the various state governments are doing with that. And yesterday, even the High Court has passed some orders in those matters. So several High Courts and Supreme Courts are dealing with issues which are presently, the country is concerned with, and that also means that the people at large need to know what's happening in these matters. Today, a general impression that is created is that digitization of courts and video conferencing hearings, which are taking place, enhance the justice delivery system. That seems to be the impression that judges are carrying, learned judges are carrying, and that is why they want to push towards this system of digitization of courts and video conferencing. But does this, do the e-courts really help or enhance the justice delivery system? Let's take a look at that. So, and before we go to that, let's also discuss about arbitration, because digitization, so whenever we talk of e-courts, we are also talking of arbitration, because having practiced in Bombay, I know that arbitration is also an important part of the court system and the dispute resolution mechanism. So today, our digitization video conferencing also used arbitration. It has traditionally been used in international arbitration for preparing pleadings, recording evidence, etc. There are several cross-border law firms who are involved, clients who are cross-border involved in arbitration. Clients who have presence across borders are involved in arbitration, and video conferencing does help in all these situations. And plus, a lot of witnesses do not have to travel to the place of arbitration. They can record their evidence sitting at their places of residence or places where they normally reside. Now, that brings me to the justice delivery system itself. Let's understand. I think that the justice delivery system is like an onion, which has the following layers. So let's start with the outermost layer. The outermost layer is the access to the system. The second layer is the engagement. By engagement, I mean the engagement of the clients and the lawyers themselves. And the engagement also means the way the clients engage with the lawyers, and the way the lawyers engage with the office or with the initial part of the litigation itself. By hearings, I mean hearings in court, and then comes the analysis of the law and the facts that are presented to the judges, and finally comes the judgment. So the justice delivery system delivers justice only when clients or clients get good judgments, or they perceive that they have achieved justice. And all this goes towards trying to get to that justice. So that is the core of the whole justice delivery system, that justice has to be achieved. So now let's take one step at a time, or one layer at a time. The first layer, according to me, is access to the justice delivery system. So looking at access, of course, digitization vastly improves the access to the justice delivery system. It is very easy to file pleadings, documents in courts from anywhere at any time. So even today, with the Supreme Court starting the e-filing portal, etc., it is very easy for lawyers to file pleadings in the Supreme Court or file documents in the Supreme Court. The Delhi High Court has been using using digitized pleadings for a long time. You could file proceedings online in the Delhi High Court for a long time. You have courts which are dedicated e-courts in the Delhi High Court also. So it also gives a lot of easy access to clients to best advocates. For example, today Mr. Harish Salve has been appearing in several matters sitting in London because he has been held up in London due to the lockdown. And he has been appearing regularly in Supreme Court. I have appeared against him in the Supreme Court in several matters, and in the high courts, etc. So he has been regularly appearing in matters from London. So that shows that, or even I have seen senior advocates appear in the Supreme Court from Kerala, from Calcutta. Yesterday, in the migrant laborers matter, I saw the Advocate General of Mizoram appear from Mizoram, I suppose. So these are, so that in a way, it's very good that the clients are able to get access to the best advocates from anywhere at any time. It also, access also means that it reduces the digitization, reduces the cost in printing, photocopying, etc. And digitization, of course, is very, very environment friendly. So all this means that yes, digitization does improve the access to the justice delivery system by the clients or by the lawyers themselves. Now that brings me to the second layer of the justice delivery system, which is engagement, which I call engagement. Now, engagement means it also improves, digitization improves the engagement with litigants and advocates. Advocates are able to give advice to litigants across the country without traveling to their respective offices. It improves engagement of the litigants with the courts in matters of filings, on deciding the calendar, etc. Engagement also enhances the quality of pleadings because everybody has access to precedents by way of e-libraries. Everybody uses several e-libraries nowadays. Several e-libraries are on offer, and people do get a chance to deal with several e-libraries sitting in the comfort of their homes. Of course, it also reduces costs of holding conferences, for drafting pleadings, for preparing evidence, etc. But now let's come to the problems. It is not easy to exhibit documents or confront witnesses with documents, etc. during video conferencing. So as far as that part of the engagement goes, it is not of any help to understand or to enhance the justice delivery system. Also, people are very gung-ho about video conferencing helping recording evidence, but there is no way of knowing whether the evidence recorded is given by the witness who is not deposing under any pressure or coercion or undue influence. So it is very easy for me to be sitting here in front of you and talking in front of a laptop, knowing that I'm, there may be a person who's pointing a gun at my head when I'm giving evidence and telling me to do what I say or what I should not say. Or maybe he's holding some loved one ransom in front of me beyond the camera, beyond the laptop, to ensure that I say what I should be saying according to him. So now this is where the problem starts. As far as access goes, it's great because it improves the access of the litigants to the justice system. But when we now come to the next layer, that is engagement, you start seeing problems in this whole setup. Though engagement also helps, digitization and video conferencing helps lawyers and litigants and advocates engage better with the system. They do help engaging systems. I have seen several junior lawyers appearing from their native place because they left Delhi to go back to their native places due to the lockdown. And now all of them are appearing from or even sending emails for circulating letters, or even small things like filing, etc., filing affidavits, etc. So they don't have to come all the way to Delhi to appear in the Supreme Court. So in a way, the second part of engagement also is better, is improving, but there are problems. That brings me to the third and a very important part of the justice delivery system, which is hearing. And what I mean by hearing is open court hearings. Our legal system recognizes open court hearings. And the best example of open court hearings is the famous trial of Balagangadhar Tilak in the Bombay High Court. So so let's take the statutory aspect of the open court hearing system. Now, Article 145 of the Constitution says that no judgment shall be delivered by Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in the open court. So Constitution also talks about open judgments in open court. Now we come to section 153B of the Code of Civil Procedure, which says that the place of trial is deemed to an open court. And it clearly says that the civil courts are deemed to an open court to which the public may generally have access so far as the same can be conveniently contain them. Now this is where we are moving away from these statutory provisions if we are now going to restrict our hearings to video conferencing. And what are we doing about that? So as the CPC says, that the judge has at any stage to decide that a particular matter must be decided in camera, or he can order that the public may not be allowed into a particular matter. Similarly, even the CRPC talks about court to be open. That means the CRPC also recognizes open court hearings. That's section 327. It says that every place court open, it should be an open court which public are given access to, except for matters such as rape, etc., which are contained in subsection 2 of that section. But generally, which the law clearly says, the civil law as well the criminal procedure code, CPC and the CRPC clearly say that courts have to be open to the public. And not only does the law does the statute lay down these provisions, but even the Supreme Court, in the famous case of Naresh Miraskar versus State of Maharashtra, which is a 9 judges judgment, has held that, I won't read it, you all will can see it on the screen. They says that trial held subject to public scrutiny and gaze naturally acts as a check against judicial caprice or vagaries, and serves as a powerful instrument for creating confidence of the public in the fairness, objectivity, and impartiality of the administration of justice. Public confidence in the administration of justice is of such great significance that there can be no opinions on the broad proposition that discharging their functions judicial trials, courts must generally hear cases in open and must permit the public admission to the courtroom. So even the Supreme Court feels that hearings have to be open court hearings. Now we come to the next important case of Swapnil Tripathi, which is versus Supreme Court of India, which is the case which relates to live streaming of proceedings in the Supreme Court. This was a case which dealt with whether the Supreme Court should live stream proceedings which are held there. And the Supreme Court accepted that view that proceedings in the Supreme Court must be streamed live. So here also, the para 64 of the judgment clearly says that legal scholars indicate principles of open justice encompass several aspects that are central to the administration of justice and rule of law. And the reason why these cases or why this open court hearing comes in is shown on the next slide. I'll just leave this slide open for a couple of minutes for everybody to read this slide, because the learned judge, Justice Chandrachud, clearly talks about why this open court hearing, what are the factors or what are the components of open justice system comprise of. And why is this open court system? That also Justice Chandrachud in his judgment says the principle underlying open justice was formulated by Lord Chief Justice Howard in justice should not only be done but manifestly and undoubtedly be seen to be done. So that's the important aspect of open court hearings. So when we have such a big, when we have the statute, when we have the judges of the Supreme Court who feel that the open court hearing must be the norm and must be the rule, and in camera proceedings must be the exception, then how can you justify video conferencing when you are making it available only to some advocates who appear in particular matters? So because I'm the standing counsel for the state of Maharashtra, I have been appearing regularly in the Supreme Court when the video conference started. In fact, I appeared in one of the first matters in which were done through video conferencing in March when the Supreme Court was under lockdown. And at that time, you could only get only the advocate on record was given the link to the hearing, and he had to pass that link on to somebody. And even today, if you see on the board of the Supreme Court, it says that if the link is shared with somebody, the link will be deactivated. Though today the link can be passed around, the advocate on record, or my advocate on record in the state for the state of Maharashtra, Mr. Patil, does pass on the link to me, and I appear in the Supreme Court regularly because the link can be passed on to me. But that still does not take care of the issue of whether the public has access to hearings which are being held to video conferencing. And especially when the statutes, the Civil Procedure Code and the Criminal Procedure Code hold that the right of the public to access to the courts is a recognized right under the provisions, how can you just take a view which is totally different from this view? And especially when the Supreme Court has permitted live streaming of court proceedings. However, the important fact is even today that judgment has not been implemented. The Supreme Court has not started live proceedings of court proceedings from the Supreme Court itself, though this judgment of Tripathi is a judgment of 2018. We are already in 2000. The COVID-19 crisis happened, or the pandemic started only in March. From 2018 to March 2020, this judgment has not been implemented by the Supreme Court. Now, one more aspect is with regard to open court hearings is that so many public interest litigations have been filed today in the pandemic period. Like the important ones I can think of is the COVID-19 in prisons, where the Supreme Court has taken so much to notice of the fact that the COVID-19 pandemic can spread very rapidly in prisons, which are very, very closed and which are enclosed spaces, and where a lot of people are staying in small area spaces. So they pass certain orders and certain directions for the states to look at the prisoners' plight, and that has led to various special committees being formed, and several prisoners who have been doing time for minor offenses have been let off. They have come out with guidelines for those, and several prisoners have benefited from that. Then there is a question of plight of migrant laborers, which is also a big issue today, and the Supreme Court has been hearing that. So none of the persons who are interested in these hearings can attend hearings at all, because yesterday, for example, in the migrant labor matters, there were at one time there were 84 to 90 lawyers who were participating in that hearings. So how do you expect judges? How do you expect the public to attend these hearings? And plus, there is no fair and accurate reporting of these hearings. What is happening is that you get live proceedings. So I don't know how this goes, but live proceedings, as the matter is being argued, are being covered on certain legal websites, but that is also not correct. Because, for example, in the plight for migrant laborers yesterday, when the turn came for the state of Maharashtra to address the judges, my connection broke down. I could not address them at that time, and the live reporting said that Maharashtra Counsel were not present in the Supreme Court. Subsequently, we did appear, we did make our presentations, but what it means is that it shows that the public is not allowed there, or that leads to a lot of inaccurate or unfair reporting as far as lawyers go also. So that's what happens is that what I'm trying to make a point here is that video conference, the hearings by video conference are not open court hearings. They are actually the opposite of open court hearings. And can we just move away from the statute and just start with video conference hearings forever in that sense, or when you are not allowed? Now, the next part of the infrastructure for video conferencing, that is something which has to be discussed. there is no standard uniform technology for video conferencing. The Supreme Court is using video, the Delhi High Court is using WebEx, Cisco WebEx, the Bombay High Court initially used video, then they use Zoom, now they use Cisco WebEx, and some judges, I'm told or informed by my friends, use Microsoft Teams. So which becomes very, very complicated for people to keep on downloading different softwares and trying to get on to different hearings in different courts. Every system which is used by any court has its own level of problems. Video has its own problems. WebEx, Cisco WebEx has its own problems. The biggest problem I face when I use Cisco WebEx is that generally the Delhi High Court does not allow you to go into the virtual conference room or a virtual room where you can wait and you can know whether you are actually, when is your matter coming up. You have to rely on the Delhi High Court virtual the board, display board, to understand what serial number is going on and what serial number is going to be taken on. So for example, if you are at serial number 9, you have to wait till you are taken into the room. So you have to watch the screen, only keep watching the screen till you find 1, 2, 3, 4, 5, 6, all these matters over. Whereas in the Supreme Court, you are taken to a sort of waiting room where you can then wait there. And then from there, you are taken to the courtroom where you can then see the judges, judges sitting in court, etc. So they at least inform you that, okay, serial number 1, we are now going to go and be ready. Serial number 2, be ready, etc. Now, the biggest problem with video is that it does not run on certain operating systems. Like the video does not work with a Mac OS Catalina system. So if this software is not robust enough to work on the latest operating systems of computers, and where are we going with these softwares? So if you have to have a iOS which is compatible to that, you have to go back 2 or 3 levels of iOS to get into that. Plus, the lack of integrated platforms is a big problem. And therefore, all this, though I agree that all this has been thrust upon us because of the pandemic, video conferencing has failed to satisfactorily provide any effective hearing. And why I say that is because we face so many problems during video conferencing. First of all, there is poor connectivity, which leads to very bad communication and resultantly bad advocacy. For example, yesterday, the judges felt that nobody was appearing for the state of Maharashtra because at the right opportune moment, both my connection as well as my advocate on records connection failed, and when the matter was going on. Then, of course, it did come back. The second point is that there is no assistance you can give to seniors. So when I appear with a senior, he connects separately, I connect separately. In one of the hearings, the learned judge asked a question about whether a particular offense was bailable or not. Now, the learned senior appearing with me is not aware of all the sections which are bailable, not bailable. So he, in his usual style and in a very nice way, he just dodged the question and moved on to the next argument. But if I was in court with him, I would have pointed out to him that a particular section was bailable or not, because that is something which I had prepared and he had not thought about that question coming from the judge. So there is no way you can assist the counsel. There is no way you can tell him what to argue or not to argue, etc., or to be of any help. Or there is no way that even a senior can look to you for a judgment which he wants. Like in the court, you would say, go run to the library and get a judgment. Plus, pleadings, referring to pleadings in a hearing is a big problem, because if you are going to refer to volume 3, page 600, it becomes very difficult for you to go up to go down to volume 3, open that page, then go down to page 600, etc. So there is no way you can point out pleadings effectively. Plus, at times, I have had hearings where the advocate comes out with a pleading or with a letter from the government which has been issued post the hearing date coming. For example, it was issued yesterday evening, for example, when today the hearing is going on, and he wants to show that to the court. And the court, there is no way he can show it to the court. It might be an important letter about one of the matters I did was where the lawyer wanted that a particular meeting should be held by video conferencing, and the government, and he had come to court for that relief, and the court was inclined to grant him relief. And then he says that he had a letter from the government department which was issued to him the earlier evening saying that yes, they were willing to consider the meeting being held by video conferencing. But that letter, there was no way to file it because it was issued in the evening, and there was no way he could point it out. So then he had to send it by email to the registrar of the court. The registrar of the court had to point it out to the judge, and the judge then referred to that letter in his order. Plus, you get a feeling that you are not part of that open hearing. You are not part of the hearing at all. Everybody is just on their respective screens and just arguing matters the way it is. So you miss that feel of the court, and where you can You can be part of that whole argument, and you get the feeling that the court. So is what's the new normal now? So this is something which today everybody accepts that the pandemic is not going to go away. So what we are thinking of is that, of course, several government offices have started working despite the pandemic, though with restricted presence. So even today, open court hearings can be conducted by giving time slots to allot time slots being allotted to matters, then by restricting number of advocates to the courtrooms or bar rooms, or restricting, even regulating mentioning by advocates, because mentioning by advocates is a big problem today also, that lawyers do not get a chance to mention their matters to get them heard before the court, because the Supreme Court or the High Courts come out with various categories of urgent matters. Now, a particular registrar may feel that your matter is not fitting into the category of urgent matters, and then it is for you to make out a case to the learned judge that this matter does come within the, or is requires urgent hearing. Now, there is no way you can actually communicate, you have to make a call, etc. There are some procedures prescribed, but practically they are all a nightmare. So now, so as a result of all this, what it means is that as you go, what you realize as you go deeper and deeper into the onion, the various layers, the video conferencing or digitization starts becoming ineffective. So the first outer layer access, it's a great system. And engagement also is okay. It works in some cases, does not work in some cases. Hearings, it's not working in that sense. Much more, it's not working at all in some places. And now we come to what is the next layer, what I mean by analysis. So once the lawyers have made their arguments, advocates have made their arguments, then the judges analyze the pleadings. So they would analyze the pleading, the facts, the evidence, and the law. And of course, the advocates play a major role in analysis as they present the facts. So as in the case, in an open case hearing, you would cite law, you would read papers, you could do that in a video conferencing matter also. But this does not aid in the analysis. You cannot aid in the analysis, or you cannot ensure that the judge has read a particular part of that, or you want to highlight a particular part. You want to, the way you read it or the way you say something to the judge is also important in an open court hearing. That is all lost. In a video conference, you have to just give the citation to the judge. He makes a note of it and he will then look at it. And he may quote it, he may not quote it. So in a way, even if digitization improves the access to the law, the precedent and the acts itself, acts themselves, but the video conferencing does not help at all in any analysis of the law or the pleadings. So the advocates get a feeling that you are not helping the judge analyze the law or analyze the pleadings at all. So there again, what e-courts have complete failure. And so basically, this is because there is no connect between the judges and as I said earlier, there is no connect between the judge and the advocates. In a video conferencing, you don't get a feeling that you are connecting to the judge. You cannot feel the reaction of a judge on a particular point. You cannot understand how he feels or how he reacts to a particular point. A particular point may appeal to a judge, a particular point may not appeal to a learned judge. So all these are very, very different things which you cannot analyze in a video conferencing. And so what the video conferencing does is that it makes the hearing very transactional. Whereas in an open court, the hearing is more argumentative or reflective. You get to see that the judge is reflecting on your point. He's accepting your point. That point is going home. He's maybe agreeing with you. He's not disagreeing with you. He's disagreeing with you for certain reasons. Then he's open to say that to you. He will say that to you why he doesn't agree with you. Then you can make arguments with that particular thing. Or he can also reflect and say, yes, what you are arguing is maybe right, but I don't, this is something which is very, something different, or whatever he wants to say. So I say that presenting the facts, evidence, and law by arguments in open court, the physical presence of judges is the only answer. And it is not possible to do this by video conferencing at all. Now that brings me to the last part of the justice delivery system, the innermost, the core of the justice delivery system, the judgment. That is where once the clients or litigants get the judgments, then they feel that justice has been achieved or not achieved. Yes, the client sometimes feels that the judge has not accepted their viewpoint and they are entitled to carry it higher to the appeal court or whatever it is. But the judgments are a co-creation of advocates and judges. So the advocates try to bring the law and the best of the law and the facts to the judge, and the judge then decides what judgment he's going to give. Judgments reflect, the judgments also show the thought process of the judges and the arguments of the advocate. So they also bring about how the judge has come to that conclusion, why he has come to the conclusion. So judgments evolve out of reflective thinking between advocates and judges. Again, as I come to that, it's not a transactional issue. It's a matter where the judges and the lawyers reflect on a particular point together and try to get to the best, to get to justice or to achieve justice. Now let's come to digitization judgments. Yes, digitization may improve the quantitative productivity of judges, but not the qualitative productivity, because you could then get several, you could access case law by the dozen, and then you can decide which is an important case to be decided, which has to be relied upon, which is not to be relied upon. But there is, as I said, there is no reflective thinking at all in a video conferencing hearing. So digitization totally fails to enhance the judicial, enhance the quality of judgments, and thus digitization and video conferencing totally fails at the final hurdle, and fails to achieve justice. Finally, why are we here? Why are we in the justice delivery system together? To achieve justice for the litigant. And that, I feel, is a complete failure when it comes to digitization or video conferencing. So what does all this mean? It means that, obviously, as I said, hearings in open court are a constitutional and statutory right affirmed time and again. So we should not lose sight of the fact that open court hearings are the norm and in-camera hearings are exceptions. I feel that video conferencing hearings conducted by video conference are more in-camera hearings. And it has always been held that open court hearings are the cornerstone of justice. And we are here to achieve justice. And because we are not able to achieve justice, I feel that the digitization video conferencing fails in the inner course or inner values of the justice delivery system. So as I again come back, if it's an onion, the first one or two layers, the outer layers, the digitization works wonders, or maybe it is working, but it is not working when it comes to the inner values or inner layers of the justice delivery system. It is possible for the courts to resume under new normal. You have to go with the time. You have to do better time management in court. It will allow litigants to come. They will maybe reduce matters, etc. But we must go back to having open court hearings at the earliest. So my submission or my summation of the whole thing is that digitization or video conferencing is not the answer, and you will have to, the judges or learned judges must go back to open court hearings as early as possible, and we must maybe think of working in the new normal. So that is the submissions or the seminar I wanted to make. Thank you very much.
Thank you, sir, for an insight on this issue. As far as the questions are concerned, I don't see any questions on the chat box yet. Anyways, our email ID is in the chat box. The participants who are here may write to us and we'll definitely get back to you. I'll hand over to Nirali for the closing remarks.
This opportunity to thank Mr. Rahul Chitnis for enlightening us on today's topic. We can't thank you enough for sharing your knowledge and expertise. I would also like to thank all participants who took out their valuable time to attend this meeting. In case of any further queries or concerns, you may reach out to the email ID in the chat box. Thank you all.